everyone. Welcome to this governance stream presentation on the new environmental protection legislation. My name is James Cleaver and I'm the Manager of Policy and Regulation at Vicwater. I'm the host of this session. I'll introduce the presenter and facilitate the questions and answers. I'll also provide a brief update on Vicwater's ongoing advocacy and engagement with government on this topic to conclude the session. Today we are using Zoom Webinar as our online platform. If you're new to Zoom Webinar, please be aware that you will not be able to switch on your camera or microphone throughout the session. If you have any questions during the presentation, please use the Q&A function to record them, and I'll read questions to Jane from that feed. To get the best possible connection, please ensure that you close all unnecessary applications that you may have open and running on your computer. And if possible, check that no one else in your household is streaming movies or anything that may put strain on your internet connection. The session today will be recorded and a link will be provided to watch in replay, available from next Monday. There will be a 20-minute break at 2:45 before we move on to the next session commencing at 3:15. It gives me great pleasure to introduce Jane Hall, who is a Senior Associate at Ashurst. Jane has experience in a wide range of environmental planning, renewable energy, real estate, and water law areas, and has a particular interest in contaminated land. Jane regularly provides advice relating to regulatory compliance, pollution issues and prosecutions, complex transactions involving contaminated land, including PFAS contaminated environments, compulsory acquisitions, general commercial property transactions, particularly in relation to the water industry, mining tenure, industrial and coal mine closures and rehabilitation, and future site reuse requirements, and environmental planning and heritage approvals around Australia. Jane has provided advice to Victorian water retailers for 20 years in relation to regulatory and commercial matters, including statutory, land access and occupational regimes, tariff settings and application, the use and disposal of biosolids, powers in relation to construction of sewers, compulsory acquisition, conditions of connection and buildovers, directors and officers insurances, transitions of the organisations between the Water Industry Act and the Water Act and the draft water bill, probity reviews of large projects, water reuse schemes and other authority works, and the rights of third parties to access water and sewerage assets. She's been heavily involved in a large number of commercial matters relating to the water industry, including in relation to development needs, development deeds, metering, supply and installation agreements, plumbing services agreements, works agreements and other authorities in relation to construction infrastructure, agreements for water assessment and retrofit programs, soil mining agreements, recycled water drought relief arrangements and recycled water agreements. Welcome, Jane. Thanks for coming.
Thanks very much, James. I think you've taken up some of my, presentation time with that very thorough introduction. So thank you very much. It's a pleasure to be here today to talk to you about the new environmental laws. I do think, in a way, I've been given a bit of an impossible task. As you might know, these are completely new environmental laws. It's the first rewrite of those laws since 1970. So trying to take you across that legislation in 40 to 45 minutes today is going to be a tough ask. But what I'm aiming to do is to give you enough of an introduction to the new regulations so that you are able to go back into your organisations and start to do a bit of a deeper dive into some of the issues that we'll talk about today that will have more or less significance for your particular organisations, depending on where you're dialing in from. So that said, what I'm hoping I can do is change the slides. Here we go. So what I'm trying to do today is to give you an overview of when this new legislation is going to commence, the general environmental duty, which is the cornerstone of the new regime, what will change in terms of the approvals that you might need to hold, give you a whistle-stop tour of some waste, noise and contaminated land duties that are going to be introduced, look at the EPA's powers and the penalties that can impose and how that might filter through to directors and officers, and then have a quick, and when I say quick, I mean quick, look at the review rights that are in the Act. So where are we now and where are we heading to? You might know that this all came about because of an independent inquiry into the EPA, which was conducted in 2016. There was a lot of community engagement and industry engagement as part of that inquiry. But the bill itself was introduced into Parliament without any pre-publication of it being made available. So the bill was introduced into Parliament. It was new to everybody other than government itself, obviously, and it passed through extremely quickly with minimal amendments and was passed in August of 2018. It was meant to commence on 1 July of this year, but COVID saw fit to delay that until 1 July of next year. And the Act does provide for a potential commencement date of December of next year, but the government's indicated that it's aiming for that 1 July of next year to start. The other thing I wanted to note was that the Act was the second Act in terms of changing the environmental laws in Victoria. The first one focused on the EPA's powers and its abilities and powers and functions itself. So it has sort of limited relevance, I guess, in terms of the duties for people conducting activities themselves. But the first thing I wanted to note was that that previous Act that changed the EPA's objectives put a focus clear and centre on not only protecting the environment as being one of EPA's core functions, but also the requirement for it to very much put human health front and centre of its decision making and the implementation of its functions. So there's that dual focus on preventing the harmful effects of pollution and waste on that dual environment and human health. And that human health really came through as a result of incidents such as the Hazelwood mine fire, where smoke and dust and odour, for example, are all things that the community can be heavily impact on their health. And so you'll see that sort of dual theme of protecting human health and the environment coming through in the rest of the presentation. Now, I understand that you get the ability to access these slides after the presentation today. I'm not running through this particular slide, but just wanted to put it in there so that you've got kind of a ready reckoner available after the event to sort of cast your mind back and remind yourself what these key changes are that we'll touch on today. So just know that that slide's there. So turning now to the general environmental duty. The point of the slide that's on the screen at the moment is to show you that this is the central change to the way that the environment is managed in Victoria as we currently know it. You'll see around the edge of that slide that there are a number of other duties, but at the core of it is this general environmental duty. And the general environmental duty, in a nutshell, requires duty holders, puts a positive obligation on duty holders to implement reasonably practicable steps to minimise the risk of harm to human health and the environment from pollution and waste. So it's a fundamental change for regulating the environment in Victoria, because at the moment it's very much a reactive system. So in other words, if there is an incident that occurs and harm is caused to the environment, that's when the EPA steps in and issues you with, for example, a pollution abatement notice or an infringement notice or enforceable undertakings or the like. The change that will be coming about with the new legislation is that it's very much about preventing that harm from occurring in the first place. And there is no current concept of that nature in the legislation at this point in time. So, for example, in a sewer spill incident at the moment, there's a sewer spill, there's a negative impact on the environment often. That's when the EPA comes in, issues you with notices to produce, investigation notices, asks you to provide it with incident reports and the like. And it may or may not result in the EPA taking some sort of enforcement action or penalty action against you. Whereas here, what the EPA is aiming to do is to look at the way that you manage, for example, the sewer system in the first place, to make sure that you've done everything that's reasonably practicable to prevent that harm from occurring in the first place. So it's a fundamental change. So what does this obligation require people to do? As I said, it puts a positive obligation on the duty holders to implement reasonably practical steps to minimise risks of harm to those dual objectives of human health and the environment. Now, if it's not practicable, reasonably practical to eliminate those risks of harm, then duty holders have to reduce those risks so far as reasonably practicable. So what does that actually mean, to reduce risks so far as reasonably practicable? It will require, for example, water authorities to very much go through their operations and their sites and assets and operations to work out, okay, well, what are the potential risks here to human health and the environment? And what are the potential mitigation strategies that we can implement for each of those specific risks that we've identified? To the extent that it's reasonably practical to do so, implementing those reasonably practicable changes or strategies identified to reduce those risks that you've identified. But then also there's that regular reviewing, considering, training, making sure that that risk identification process is representing best practice and is still suitable over a period of time. So I guess the point I'm trying to make here is that it's not going to be good enough to just have a generic off-the-shelf risk assessment. You might be able to have a generic risk assessment that gives you some sort of key risks that are common across all of your operations and activities. But at the end of the day, you are going to need to drill down into each particular action that you take, site that you operate, to identify the particular risks that are present from those operations. And then need to tailor your training and other programs around those specific risks. Who does the, I call it the GED, General Environmental Duty, apply to? It applies to people that are engaging in an activity that may give rise to risks of harm. So if you're conducting, undertaking, managing, or in control of an activity, which includes storing and possessing wastes, for example, the General Environmental Duty will apply to you. The other thing I wanted to note was that liability also can extend to upstream duty holders as well. So if you're engaging contractors to design and build a treatment plant for you, for example, then to the extent that contractor is designing, manufacturing, installing, or supplying plant and equipment for you, then they will also be under an obligation to design that system in a way that minimises pollution or waste when used in the way that that system was intended, and to provide you with the necessary information as the operator of that system to ensure that the product can be used in that way intended. So what does reasonably practicable mean? Because that's obviously a key consideration to whether you're meeting your duty to minimise the risk of harm. Obviously, it will depend on your particular operations and the facts of the case. But at the end of the day, there are a number of factors that the Act identifies that will be relevant to that consideration. So what's the likelihood of the risk eventuating, and what's the degree of harm that would result? So that probably isn't that unusual, or that's a pretty standard risk assessment technique. But in terms of knowledge that you need to consider about the knowledge about the risks of harm, as well as the knowledge about the ways of eliminating or reducing those risks. But don't think that that's just actual knowledge. It's also what you should be aware, or what you ought reasonably to know. So that head in the sand approach isn't going to be good enough. And you'll be glad to know that the availability, suitability and cost of eliminating or reducing those risks is also a relevant factor to be considered. The other thing just to note is that permissions, which I'll come to next, can actually include conditions around measures that that permission holder must do in order to meet the general environmental duty when engaging in the activity that's authorised by that permission. So just bear that in mind as well. Now, many of you might be familiar with the occupational health and safety area, and this might sound quite familiar to you because the general environmental duty is modelled on the general duty provisions in the Occupational Health and Safety Act. So cases that are in that area of law, in the OH&S area, are going to be relevant to understanding what the EPA will be looking for in terms of determining whether a duty holder has met this excuse me, general environmental duty. At the end of the day, it's an objective test. You don't have to, it doesn't require that all incidents or risks be eliminated. But again, it comes back to whether you've taken reasonable steps to eliminate or at least reduce those risks as much as possible. So you can see on the slide here, there was a case which involved a worker who was killed from falling from a piling machine that wasn't bolted together properly. And the court in that case held that the risk of the machine collapsing was a risk, including a warning in the manual was an easy measure that could have been implemented to reduce or eliminate that risk. And it was reasonably practicable in the circumstances to include that warning. So that the duty had not been made out in that case. So I did tell you and warn you it was going to be a whistle-stop tour. So moving right along to the permissions regime. You might be familiar with the works approval and licensing system that's currently in place in Victoria. In effect, the works approval will continue on, but it will be known as a development licence. It will be still advertised. If you're applying for a works approval, there will still be public advertising of that application. And that is the approval that you need to sort of build your operating plant in the first place. So for example, sewage treatment will be a prescribed activity that requires a development licence, and that reflects the fact that it's already requires a works approval for that activity currently. The licence, the discharge licence, will be known as an operating licence. And I think it's fair to say that even though we've only had draft regulations so far, if you've got a licence now, you will need an operating licence in the future. Those licences will be able to be reviewed periodically by the EPA, I think every 4 years or a longer period allowed by the EPA. And generally they'll be in force for 20 years. And again, sewage treatment is an example of an activity that will require an operating licence. Then you can see that instead of just having that sort of one size fits all big ticket polluters requiring a licence, they've also introduced a tiered system of other approvals. So there will be lower risk activities that require permits, and then lower risk activities again that require registrations. So in terms of an example of a permit requirement, biosolid supply or use will require a permit. And the temporary storage of asbestos is an example of, and again, based on the draft regulations that we've got, of an activity that will require a registration. Now, obviously, the process to go about getting the permits and registrations is simpler than getting a licence, and basically the ease of getting that approval, lower down the pyramid, it's easier to get. It's more sort of an administrative process through to the full assessment of the licence application. Just touching on the fact that if you've got a works approval or a licence now, then that will transition across to be the equivalent permission under the new regime. The EPA will have an ability for a 12-month period after the Act commences to review the conditions that apply to those existing approvals. The other thing to note is that if you are in the middle of applying for a permission at the time that the Act transitions to the new regime, then your application will be taken to be an application for the new type of permission. But you'll be given a reasonable opportunity to be able to provide further information to the EPA in support of that application to meet the requirements of the new permission regime. So moving right along, again, whistle-stop tour, noise. Now, being able to cover the topic of noise in one slide is extremely difficult, so I'm just going to touch on a few of the main changes. The new legislation, unsurprisingly, establishes duties and offences in relation to the control of unreasonable and aggravated noise. In relation to commercial, industrial and trade premises, noise levels are not to exceed noise limits within noise-sensitive areas. Now, that picks up the fact that there are a couple of new environmental values and therefore new noise-sensitive areas which cover childhood learning and development, as well as human tranquility and enjoyment of outdoor natural areas, which is all about protecting all types of educational facilities, whether they're kindergartens or high schools, as well as, for example, camping and caravan parks. And as I said, there's new noise-sensitive areas to reflect those new values, as well as the ones you might already be familiar with under the current regulatory controls for noise, which are in a SEP and a NERV, which will disappear into the new regulations and the environment reference standards. So where you find obligations will also be different under the new regime. The other thing to note is that the obligations for noise control for commercial, industrial and trade premises in regional Victoria will now be contained in the regulations instead of just being EPA guidance. And there are different measures, measurement methods provided for in relation to measuring noise in urban and rural areas. So that in a nutshell is sort of the highlights of the new developments for noise. Now, waste is quite a difficult topic I often find to explain in hopefully a simple way. So I've stolen the image on the screen in terms of the buckets from some EPA publications that I hope makes the task simpler to explain. So the broadest type of waste is industrial waste, and that's the big blue bucket on the left-hand side. And you can see there that it's a pretty broad definition: waste arising from commercial, industrial or trade activities or from labs. And for the first time, it's actually possible also to prescribe waste to be industrial waste under the new regime. Now, coming out of that big overarching bucket is a smaller bucket, priority waste bucket, which is the light blue bucket. So for example, biosolids will fit into that priority waste bucket. So these are wastes that require some additional control because they've got higher hazard levels, for example, and they've got a greater potential to harm the environment if they're not managed appropriately. So there are greater controls applying to those priority wastes. And then inside that light blue bucket, there are also even sort of more wastes that require even higher levels of control, and they're going to be known as reportable priority wastes. So that will be, for example, PFAS and asbestos. And again, that sort of ups the level of control for those types of wastes. But at the end of the day, because each of the buckets fit into each other, the reportable priority waste obligations are in addition to whatever applies to the other types of waste as well. So you have to comply with all of the obligations if you're dealing with reportable priority waste. But if what you've got is industrial waste, there's a more sort of limited set of obligations that apply. The purpose of this slide is to merely highlight the fact that there will be a number of duties that apply to wastes, and depending on what type of waste that you're dealing with, there'll be different duties. But also the point of this slide is merely to highlight that different people will have different duties along the way. So, to try and make that clearer, there's, I guess, a number of points in the process of dealing with waste where you need to ask yourself some questions. So, for example, at the very start, well, what waste am I dealing with? And the new legislation tries to make that classification system much simpler than the current system by having a list of what they call pre-classified wastes in the draft regulations. So you have an obligation to identify what waste you have. Then you need to think about, well, now that I know what waste I've got, how much have I got of that waste? Because you need to think about, well, do I need a permission to hold that waste in that quantity at that location? Now, some wastes, you might be familiar with the waste hierarchy, which makes landfilling of waste at the bottom of that hierarchy. So there might be obligations to investigate whether you need to reuse, recycle, or identify other ways of disposing or reusing your waste other than sending it to landfill. Then if you're actually transporting it somewhere or proposing to consign it for transportation by somebody else, then there'll be another set of questions that you need to ask. If it's priority waste, is the vehicle itself and the driver licensed to take it? And does the transportation of that waste need a permission? You also need to check when you're consigning it to somebody to transport, are they taking it, or you need to use reasonable endeavours to ensure that they're taking it to somewhere that is authorised to receive the waste. So you'll see that is step 5, making sure it goes somewhere that's authorised to receive it. So there are a number of obligations in relation to industrial waste. It's an offence to get rid of it somewhere that's not licensed to take it. It's also an offence to deposit it somewhere without obtaining consent from the person that's in control of that place that's authorised to take it. So you can't sort of sneak in there in the middle of the night and just dump it without obviously having the authorisation of the person to do that. And as I said, when you're relinquishing management or control for transportation, you need to take reasonable steps to ensure it's going somewhere that's authorised. And that light purple box sort of gives you a flavour of the sorts of steps that you need to take to ensure that you're meeting that duty when you're consigning that waste to somebody to transport it somewhere else. As I said, priority waste is the equivalent now of the prescribed industrial waste system. And you can see there that there are new duties in relation to that priority waste, including containing it to prevent its escape, isolating it to ensure that resource recovery remains practicable, and providing information to the next people in the waste chain to make sure that the hazards associated with that waste are known, and so they can be appropriately collected and consigned and transferred and deposited in light of that hazard categorisation. And as I said, the subset of priority waste is reportable priority waste, which also requires that the EPA is notified when it moves through that waste chain. So in terms of contaminated land obligations, currently you might be aware, if you are occupying a contaminated site, unless the EPA issues you with some form of statutory notice, there is no obligation to really do anything with that contaminated site. Under the new Act, there will be duties in relation to contaminated land, and that's broadly the duty to manage it as well as the duty to notify the EPA. So land will be contaminated if a chemical substance or a waste or a prescribed substance is present on or under the surface of the land above effectively background concentrations or naturally occurring concentrations, and has to present a risk of harm to human health or the environment. The slide refers to land in a number of circumstances there. That includes groundwater, but doesn't include surface water. So if you are in management or control of contaminated land, you must minimise the risks of harm as so far as reasonably practicable in relation to that contamination. So that might require that you identify that contamination, investigate and assess it, and then minimise the risks of harm, which obviously can include having an obligation to clean it up, as well, again, as we're seeing this flow of information, the requirement to provide information to people who might be affected. In terms of the duty to notify, again, it refers to the person in management of control of that contaminated land. There's an obligation to notify the EPA as soon as reasonably practicable of notifiable contamination. Now, notifiable contamination is defined in the Act as where remediation of that contamination is likely to exceed $50,000. Now, that's obviously quite a low threshold when you think about engaging consultants and having to actually, you know, for example, dig and dump contaminated soil. You get to $50,000 pretty quickly. However, the draft regulations contained very detailed provisions about what will be notifiable contamination. And I guess in the feedback that I was involved with generating for clients that was given to the EPA was very much of the nature that, you know, it's impossible for anybody that doesn't have, you know, an environmental science degree or whatever degree, you know, consultants have, to be able to decide whether they've got notifiable contamination or not. So I'm not quite sure where that will end up in the regulations when they're finalised and released. But, you know, bear in mind that it was quite a technical definition, and that you would, most people I think would need assistance to work out if they had notifiable contamination or not. So the EPA can serve what's known as a site management order on the current owner or occupier of contaminated land if they think that it's necessary, that long-term management is necessary because of that contamination, or again, because there's a risk of harm to human health or the environment. Bear in mind that that site management order effectively runs with the land and binds subsequent owners, occupiers and people in management and control of the site. And that's something that's new. So if you currently get a cleanup notice from the EPA, that is issued to you personally and doesn't run with the land. So that's a new, I guess, technique for the EPA to ensure that land is managed appropriately on an ongoing basis, despite being sort of transacted between people. You'll be glad to know that the polluter pays principle is still enshrined in the legislation, and to the extent that you incur costs either by complying with your duties to manage or in complying with a site management order, you do have a statutory right to recover against the polluter. There's also new obligations in relation to pollution incidents. As you might know, currently, unless you've got a licence that requires you to notify the EPA of non-compliance with that licence, if you have an environmental incident, there's no obligation to tell the EPA, and there's no obligation to actually do anything about that incident. I have a feeling that this, in theory, the duty to restore the environment is probably nothing new. I'm sure that your organisations, if you've spilt something, you clean it up. It's just the right thing to do and minimise risks. But that is now a statutory duty. Then if there's an incident that's caused or threatened to cause material harm, you will now have an obligation to notify the EPA. And material harm, again, the threshold for what that means, you'll see down the bottom there, is currently set at $10,000, which again is not a lot in terms of fixing up an environmental issue. So just be aware, if you have an incident now, you might have various obligations that arise from that. So turning now to the EPA's powers and penalties. I'm not going to spend a huge amount of time on this, just to note that the EPA does have a range of powers, as you'd expect, and they've been modernised to some extent. So powers to enter and inspect, require production of documents, require information or people to answer questions and to give directions, all of that remains. They have the ability to use modern surveillance technology, which, as I said, a lot of their powers have been modernised. There's a number of notices that can be given by the EPA, and I'll come to that in the next slide. And bear in mind that the EPA does retain the ability to clean up environmental issues that present risk of harm itself, and then recover its reasonable costs. So, for example, from the occupier. So a number of notices are now created. So instead of just having a pollution abatement notice, for example, and a cleanup notice, there's a whole range of new notices that the EPA is going to be able to serve. Just focus on one of them, which is the environmental action notice. Just wanted to focus on that one as an example because it broadens the range of people also that can be served with this type of notice. So at the moment, a cleanup notice, for example, can be served on the current occupier of the site or effectively the polluter, whereas an environmental action notice can be served on the current owner or occupier, a previous owner or occupier at the time that the circumstances arose, as well as the polluter. So don't think that because you were a previous owner and you've now divested yourself of that site, if you had a tenant on that site creating pollution or contamination at the time you were an owner, the fact that you've moved on and sold the site doesn't mean that you won't be responsible potentially for complying, or you might be in the firing line from the EPA in terms of receiving an environmental action notice. So it does broaden the category of people that could be exposed to liability. I don't want you to focus necessarily on the detail on this slide. I think the key takeaway message from this slide is that the penalties now are going to be much greater than they were before, which is probably not surprising. The other thing is that you can see that a breach of the general environmental duty for aggravated breaches, it's a pretty stiff penalty of $3.3 million. So we're not talking about small penalties. And even for the breach of conditions and operating without necessary permissions, you'll see that the amount of the penalties that can be imposed are significantly higher now. I just wanted to touch on a few penalties and sanctions. You can see there that there aren't really that many defences. There's a defence of an emergency. But in terms of penalties and sanctions, just again focusing on sort of the key things that I want you to take away from this is that instead of the EPA having to prosecute for a criminal offence, a number of the contraventions of the Act are now called what we call civil penalties. So it is easier for the EPA to seek a civil penalty contravention rather than a criminal sanction, because the burden of proof and the evidence that they have to provide is at a lower standard. So the burden that they have to get over to make out the offence is at a lower standard. So again, it, I guess, encourages the EPA, instead of only prosecuting those really obvious offences, they might end up having a go at more of the offences, but on a civil basis rather than a criminal basis. So it will make it, I guess, finalised faster for the EPA, easier to prove, but, you know, obviously it sort of potentially exposes people to being prosecuted more often by the EPA. The other thing I wanted to note was that there is this creature in the legislation called a Better Environment Plan, and that effectively is trying to move the EPA from having to control behaviour by issuing notices, by enabling people to enter into a better environment plan with the EPA. So it's in theory designed to enable people to develop innovative ways to comply or to exceed compliance with the Act, and to facilitate voluntary collaboration between people who have to comply and the EPA. So they can formally endorse, these plans can formally endorse voluntary action and leadership. And so you can submit a plan to the EPA for acceptance. And to the extent to which the plan states that if you act in a certain way or deliver certain things, you're complying with a duty or satisfying an obligation, then if you comply with that plan, you're taken to meet that obligation under the Act. So I thought that just might be interesting for you to know about. The other thing that's really a fundamental change for environmental law in Victoria is this right of the community to seek civil remedies. So community members as well as the EPA, but mainly I'm coming from it from the community perspective, because this is going to be potentially a big change for organisations, is that they'll see members of the community applying to the court for an order to restrain a person from engaging in conduct that is a breach of a permission or, for example, the general environmental duty, or asking the court to make somebody do a specific action. So, for example, to remedy some form of activity that the community member thinks they're not, you know, doing the right thing. So if a community member's interests are affected, then they will be able to seek these orders. But other people, regardless of whether their interests have been affected, will also be able to apply if they have asked they'll need the leave of the court, and the leave of the court will be granted if it's in the public interest and the EPA has been asked to do something about it and hasn't done so in a reasonable time. So if you've got an aggrieved community member who's asked the EPA to take some sort of action to prevent something from occurring, and the EPA fails to do so within a reasonable time, I'm not quite sure how you determine what's reasonable, but they've failed to do anything, then the person may be given leave by the court to obtain one of these civil remedies. So that's a big, I guess, change, because it gives the public for the first time a right to potentially seek to enforce the law if they think the EPA has failed to do so. Now, directors and officers, I think, is quite an interesting topic for this audience, in that the officer liability provisions in the Act only apply to body corporates that are corporations within the meaning of a particular section of the Corporations Act. And that corporation includes any body corporate, but not an exempt public authority. And an exempt public authority is a body corporate that's incorporated within Australia and is a public authority, which isn't actually defined. So given the status of water authorities in Victoria under the Public Administration Act, and being public entities and being effectively corporations with a public purpose under the Water Act, query whether, and I don't know if this was deliberate, whether the officers are in fact exposed under the Act. So I'm just conscious of the time, so I'm going to keep going now to reviews the review rights under the regime. Just wanted to note that it's more a standardised approach for the EPA to be able to be asked to review its own decisions. So currently it depends on whether you've got a cleanup notice or a pollution abatement notice, and sometimes you have a right to seek internal review by the EPA and other times you don't. The new regime really puts beyond doubt that you can apply to the EPA for review of a decision to issue a notice or to amend a notice. And you can see there that it applies to a range of notices that the EPA can issue, including the improvement notice, prohibition notice, notice to investigate, or an environmental action notice. And unsurprisingly, the EPA can either affirm its decision, vary the decision, or make a new decision. Eligible people can apply to have the merits of certain decisions reviewed at VCAT. So for example, if a licence or permit has been refused by the EPA, or they've refused to amend it, or they've require security for cleanup costs, or they've made a decision to issue some of the notices that we've talked about, or they've decided to issue or direct a body corporate to comply with a notice or order, there are certain eligible people that will be able to apply to VCAT for a review of the EPA's decision. So the Act goes through, you know, what are these reviewable decisions and who is an eligible person. The other thing I wanted to note is that there are third-party review rights now. So a third party, or in other words, potentially a community member, has review rights. If they're not an eligible person, they still might get a look in at VCAT if their interests are affected by a decision. Now, currently the only decisions that are subject to this appeal right is the issue of a development licence, or what we currently know as a works approval, the issue of a works approval by the EPA, or removing the suspension of a licence. But I guess the ability for the community member to challenge the issue of a works approval is significant. So again, you know, ensuring that you've got great community engagement and you're trying to respond to issues at an earlier stage is a good thing in terms of works approval applications or development licence applications. But bear in mind that the grounds upon which an appeal can be made are limited to those grounds, 4 grounds that are on the slide there. But you know, they are still quite broadly drafted, and obviously we don't have any judicial guidance to give us any indication about the extent to which these third-party appeal rights will be possible at this stage. But you know, again, it comes back to the more that you can sort of engage with and deal with any I guess community angst or community concerns in relation to what you're doing at an earlier stage, then hopefully you'd be able to minimise the risks of this third-party appeal rights down the track. So I don't know if I've done that justice, but that's sort of the whistle-top tour that I'm trying to give you, to sort of give you the key components of the legislation so that you can go back to your organisations and start to think about whether your organisations are starting to prepare adequately to be able to, in particular, meet the general environmental duty when it starts, presumably on 1 July of next year. So I will stop sharing and I guess ask if there are any questions.
Yes, thank you very much, Jane. So I've got some questions here, and just a reminder that any further questions you can feel free to type into the Q&A box as we continue. So the first question is in relation to emerging contaminants, which is going to be a major focus for the water industry in the coming years. And so since a significant proportion of emerging contaminants in the wastewater discharge will have originated from industrial waste discharges to the sewer, can you share your thoughts on how the GED changes obligations for upstream industrial waste sources?
Yeah, sure. Good question, James. I think the overarching comment I would make is that currently there are obviously controls around discharges to sewer, whether that's sort of under a trade waste agreement or depending on the nature of the operations, there may be an EPA discharge licence in place that's also relevant. And those, I guess, licenses often have generic conditions in them about, you know, ensuring that storm water is not contaminated, for example. So currently they're the main controls on those industrial sites. I think the point to note with the general environmental duty is that a number of different people in a supply chain or in the environment can be subject to the duty. So the water authorities at the sewer treatment plant will be subject to a duty to manage it at their end, but the industrial sites themselves will have obligations to comply with that general environmental duty in relation to their operations. So, for example, they need to use and maintain plant, equipment, processes and systems in a manner that minimises the risk of harm. Are they identifying, assessing and controlling risks in relation to those risks that they've identified, and are they constantly evaluating whether those controls are appropriate? Are they ensuring that all substances are handled and used and stored in a manner that minimises risks? And are they providing adequate supervision and instruction to their employees to ensure that those risks are managed? I guess in terms of emerging contaminants, though, at the end of the day, what is reasonably practical will come back down to, though, what is the level of understanding about the risks associated with those emerging contaminants? Are there practical and cost-effective methods to sort of minimise that risk? So I think it comes back to what we've already sort of talked about, is that, you know, just knowing vaguely that there's some sort of generic concern about an emergent contaminant might not mean that you have to do very much. But if it becomes apparent that these are, you know, serious things that need to be appropriately managed, then that level of what is reasonable is likely to increase in terms of what the EPA's expectations are. But so I think really to answer your question is, instead of just being controlled by statutory documents, the EPA will be able to look at those upstream sources. And I guess one of the entire reasons for the general environmental duty being implemented in the first place was because the EPA saw that there was there's a gap, I guess, or a shortfall with the current legislation, in that really the licensing system only targets, you know, the biggest polluters and the point sources from those biggest polluters, whereas often the environmental issues that we're facing are very much a diffuse source problem, and that everybody should be under an obligation to contribute to managing that issue.
Yeah, thank you very much. Jane, I've just seen a couple of questions come up now. The first one is in relation to expansion of the EPA's role and their resources and capabilities to deliver. I suppose I might have a crack at that one to begin with, to take the pressure off you, but you can feel free to add something. So going back about 2 years or so, when the legislation was first in development, in the state government budget at that time, there was a significant increase in funding for the EPA. I don't know exactly what the numbers were off the top of my head, but their staffing levels have roughly doubled over the last couple of years. And so EPA has been onboarding a huge number of new staff, and it's been it's been a focus of mine and Vic Waters and a number of people in the industry to make sure that we're engaging really well across these new staff members that don't necessarily have the existing relationships or a background in the water industry. So yeah, the EPA's staffing numbers and budget has significantly increased to accompany the new Act. So Jane, do you have anything to add to that question or answer?
No, only to the extent, I guess, to which I think it needs to, because I don't know, often as a practitioner, it can be very frustrating if, you know, the simple things aren't done correctly. So I think the, you know, the current situation was that the EPA staff were very much under pressure and had a lot, you know, too much work to do and not enough time to do it in. So I mean, from our perspective, there'd be sort of, you know, things that should, you know, you would think would be picked up, or, you know, I guess what I would be hoping was that they would have enough people to be able to sort of really engage properly with the issues. But also, I mean, I sort of found it frustrating that if you didn't send it to the right person within the EPA, they didn't necessarily sort of facilitate it getting to the right person, and they would just sort of not respond, or, you know, you'd have to follow them up and say, oh, you'd sort of get a, oh, well, that's not me kind of response, instead of, you know, I mean, I don't know if I'm hoping for too much, but you sort of hope that they will get to a stage where they really do facilitate people navigating their way through the EPA, because I often find it a bit frustrating that it's sort of, it was quite siloed. So if you were sort of dealing with an enforcement action that related to a license issue as well, you had to deal with different people. So I don't know whether we'll ever get to the stage of it being a bit more sort of linked up, but that would hopefully be my desire as a practitioner.
Yeah, a few ongoing challenges there for me too. So coming back to the Q&A box, there's a question in relation to personal liability. So can you please clarify the potential liability for directors of water corps?
Yeah, so there are the derivative liability provisions, the officer's liability provisions, apply to a body corporate that are corporations within a certain section of the Corporations Act. So currently, I'll sort of go back a step. Currently, derivative liability provisions apply to persons who are directors or persons concerned in the management of the corporation. So as soon as the company commits an offence, each person who's a director or person concerned in the management of that corporation is automatically guilty of the same offence that the corporation has committed, unless they've got one of the defences, which is they didn't exercise due diligence, they weren't in a position to influence, for example. Now, not being in a position to influence is quite difficult for, say, a director, because arguably they do have the ability to influence the conduct of the corporation. In the new Act, though, the officers' liability provisions are linked to this notion that it applies to body corporates within this particular section of the Corporations Act. But that doesn't include exempt public authorities. So, as I said, it's a body corporate incorporated within Australia that is a public authority or an instrumentality or agency of the Crown in right of Victoria. So in our view, given the public nature of water authorities in Victoria, they would be an exempt public authority, which would mean that the officer's liability provisions don't apply. Now, I don't know, James, if you've had any dealings with the EPA or, you know, the department in relation to that, but that's our preliminary view, is that that's the way it's drafted. And given the Public Administration Act makes, you know, organisations public entities, for example, and as I said, water corporations have been established for a public purpose under the Water Act and definitely carry out public purposes, you would argue that they're a public authority.
Yeah, well, I think that's something that we're going to need to follow up. But yeah, thank you for that answer. So coming back to the Q&A box, there's a question there which you might be able to read yourself as well, Jane.
I haven't been looking. I'm relying on you, James. Sorry.
It's a long one that well, I'm going to try and pull a thread out of that, but it's a little bit complicated. So first of all, the question is relating to an experience where the EPA has required actions of an entity via a draft PAN, and the entity trying to enter into a dialogue or a negotiation about the implementation of those actions, and EPA rejecting that dialogue or negotiation. And so the question is about whether EPA really had a basis on which to reject that sort of dialogue in the past, and whether that's changed under the new Act.
I think what I can say about that is I think we've acted for people that have had very similar experiences. So often notices will be issued in draft and they'll ask for your comments, and really at the end of the day, unless you're trying to change a compliance date because you're saying it's unreasonable and you need longer, often the EPA is not that interested in amending anything else. So for example, there's usually a number of observations that the EPA makes in these draft notices, and you can have limited success. You can put a lot of time into responding to these draft notices but have a limited success in terms of being able to get the EPA to actually change what ends up being in the notice. So I think the first thing I would sort of do is acknowledge that, I had clients that have had a very similar experience, and you kind of then wonder, why am I wasting my time trying to have these conversations? You've asked for feedback, and usually it's worded in a way where they're only asking for specific feedback about, the compliance dates and whether the examples given of how you can comply are quite clear enough to help you, sort of thing. But often it sort of seems to fall on deaf ears. Look, I'm not quite sure that I haven't sort of looked into whether there's any requirement for them to issue drafts of the notices. I don't recall seeing anything in the legislation, which is current with the current practice, so that they give you the draft notices. They're not required to by the legislation. So I think that, as I said, I can't recall them having an obligation to provide drafts for comment. And look, I think it probably comes back to, I don't know that it will change, to be brutally honest. I guess it comes back to how the EPA will approach enforcement of the new regime. So my understanding is it's more about education and bringing people up to speed and bringing people on the journey and acting as an educator at the initial stages. And whether that can be used to sort of, argue that they should be talking to you and actually listening to the views that you have in these draft notices. I'm not quite sure. They do also have I think the last time I saw it was a draft consultation strategy, or I can't exactly remember what it was called. I had a quick squiz at it at the time it was released in draft, and I didn't think it really said very much. But in terms of being dramatically different from the current system. But I must admit, I didn't sort of read it from that draft notice perspective. So I don't know whether there's something in that consultation strategy about when they will or won't sort of consider people's comments on draft notices in particular. So I don't know if that's helped, but I hear the frustration. I don't know that anything's going to change in the legislation, that's for sure. Whether they adopt a different approach because they're trying to be more of an education, in the first couple of years, I'm not quite sure.
Yeah, thanks, Jane. And I apologise if I fluffed the question a little bit, because I'm more involved in the upfront negotiation of the policy work than any prosecutions. But thank you very much for clarifying that for me. So I might ask one more question, then we'll skip on to some of the policy work that's going on a Vic-Water. So I'd like to just identify the most striking feature for me in the new legislation, which is that the GED replaces reams of detailed specifications relating to environmental compliance. And so, for instance, much of the content of the SEP waters has been subsumed by the GED. So what advice do you have for board directors on how to approach the concept of so far as reasonably practicable?
Yeah, I guess the first thing I'd note is that, yes, the SEPs are going. So currently we've got state environment protection policies, which I don't know if people have ever tried to make head nor tail of them, but it was always hard going as far as I was concerned, because you'd find that there was a mixture of, sections on what decision makers had to consider, and then there were sort of limits about, well, if you've found this, then you've got to do X. So they sort of had a mixture of decision-making criteria and then a mixture of requirements in relation to what you've got to do if certain things happen. And then there were sort of these general parameters around, for example, beneficial uses and what the triggers were and what you had to protect, and, sort of setting out the framework for the environmental controls in terms of what the EPA is trying to actually achieve in terms of protection of the environment. So the SEPs were a mixture of a huge number of different things, trying to do a number of different purposes, and it was always a bit of a minefield trying to work them out. So I think most practitioners that were dealing with SEPs are probably not that sad to see them go. But that said, because they had a number of different things in them, they actually are not just being sort of ditched into the rubbish bin completely. So you might find that some of the bits that were in them will end up in the draft, in the regulations once we get the finalised version. Some will end up in the environmental reference standards. So, for example, the environmental values, indicators and objectives will end up in the environmental reference standards. And some of them, around what the EPA has to consider when making decisions will also go to the regulations. So I don't want people to think that what's in the SEPs now just disappears, because some of it does end up in different places. So have a bit of a hunt around is probably the first thing. If you can't find this, if you wanted to know that it's still around, have a look in a number of different places. The other thing to note is that the SEP waters will continue, some clauses of that will continue on for a couple of years after the new regime commences. So just be aware that some clauses, there are transitional provisions that mean that they'll hang around for longer. And my understanding is that, for example, that some of the, I'm just having a look at the term obligations on managers of land and infrastructure, and OMLI, which is a bit of a mouthful. So there is going to be this separate document type, and I don't really know much more about it, but this separate obligation on managers of land and infrastructure, which you would presumably assume includes the water authorities. There will be this separate document that provides some sort of, I guess, statutory guidance or control in those documents as well. And that is my sort of understanding, is that the SEP will continue on until things like this obligations on land and infrastructure managers come out. So I guess the first thing to note is that the SEPs are going in all different directions. Some bits will last on and will be replaced by other instruments. In terms of what so far as reasonably practicable means, I think even though the SEPs might disappear, I think they probably provide a good starting point for determining what is reasonably practicable. Sometimes it will, even though they might not be there anymore, it might inform that standard of care expected of a person conducting the activity in terms of how they comply with the general environmental duty. So And then coming back to that slide that had the different, you know, what is reasonably practicable, then each of those sort of circles around that what is reasonably practical will be relevant again.
Yeah. So thank you very much, Jane. That was an excellent coverage of that question and all of the questions. So we've got a few minutes to go. As I forecast at the start of the session, it's just going to provide a brief update on some work that's going on at Vickwater on this topic to hopefully answer some of the questions and challenges that remain. And so Vickwater's been involved in these reforms for many years, since the 2015 independent inquiry into the EPA. And throughout that time, we've promoted a more flexible risk-based environmental compliance framework. And the key lesson from all the Vickwater policy work is that the details matter and that the specific wording of a single clause can be hugely influential in determining the future cost and complexity of compliance. And so as these reforms have gathered pace and more detailed subordinate instruments have been drafted, Vickwater's engagement with EPA has stepped up a gear. And this includes detailed negotiation on the content of recently published draft regulations and operating licence conditions. And reflecting on this, there's been a realisation regarding the fundamental shift facing the water sector under the new framework. And that's that the EPA and the EPA Act and the subordinate instruments previously served a sort of a dual purpose where they were both the compliance standard, but they also created an operational standard for the water industry. So things like the 1 in 5 hydraulic containment standard for the sewer network and licensed discharge limits serve the EPA as their compliance standard, and they also serve the water industry from an operational point of view. So water corporations had the certainty of a clear operational standard, which was also recognised by the economic regulator. And this allowed the industry to focus on efficient implementation. So the subordinate instruments developed to support the implementation of the GED provide much less clarity from an operational point of view. So for example, there's a new licence condition, which includes a requirement that entities describe how they will eliminate or minimise risks so far as reasonably practicable. So that adds a new type of accountability for water corporations to devise the reasonably practicable approach to assess the risks, assess controls, and implement practicable controls on a site-by-site basis and an activity-by-activity basis. So the EPA point out that the legislation gives industries power to define and take control of the standard of reasonably practicable by documenting it in better environment plans, as discussed earlier, industry projects, guides and codes of practice, and that these would become reference documents under the EP Act, and the EPA would be required to consider them in compliance and enforcement activities. So there's a pathway provided by the legislation for the water industry to operationalise the GED that reduces the subjectivity of enforcement and creates a consistent basis for the economic regulator to consider investment in environmental outcomes. So the objective would not be to define new prescriptive standards like a new 1 in 5 sewage containment standard, but rather the reference documents would set out the approach to assess and manage risks and identify cost-effective controls so that individual water corporations have the operational certainty and can focus on delivery. So a proactive effort by the water industry is going to be required. And Vickwater's recently established a new policy advisory committee that has identified environmental stewardship under the GED as a strategic policy priority and will oversee a work program to create these operational reference documents. The committee hosted a policy forum on June 17 and 18 this year, which included extensive discussion on this topic. And since the forum, the committee is overseeing the preparation of a Vickwater policy platform, which addresses this and a number of other strategic policy issues. The Vickwater policy platform is going through a review and refinement process by MDs and independent experts before being tabled for endorsement by the Vickwater Board and the Vickwater Council later in the year. So Vickwater is responding to member feedback to be the leading advocate for Victorian water corporations to develop consistent policy that represents the sector and reduce red tape. And these environmental policy reforms provide an excellent opportunity to reflect that ambition. I'm personally very excited by the challenge and opportunity for the sector in the new environmental protection legislation, where I'm certain that we can get a better outcome by working together. Once again, thank you to Jane. Remember that a replay will be available next week, and we'll now pause for a 20-minute break. The next session will commence at 3:15. Thank you.
Thank you.